Welcome back to the Public Service Commission of South Carolina and the hearing in dockets 2022-93E and 2022-97E. Let's do a quick roll call of commissioners. Present in the hearing room, we have Commissioner Jay Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Caston, Chair Belser, and with us virtually we have Commissioner Irvin and Commissioner Carol Lee Williams. We are still in the applicant's case, so the chair recognizes Mr. Adams.
Yes, ma'am. Just as an initial matter, if possible, we'd like to let Mr. Kisper be excused at this point. He's got a full afternoon, and I think we can make do without him from this point if you're comfortable with that.
Mr. Adams, it's not whether I'm comfortable with it, it's whether you are.
I am comfortable with it. Yes, ma'am.
Okay. Then Mr. Kisper is excused. Thank you for being with us today.
Thank you. Thanks, Matt. Chair Belser, I'm going to turn the wheel over to Court Walsh to handle the next two witnesses. So, Court, you can take it from here.
Mr. Walsh, you are recognized.
Chair Belser, thank you. Chair and commissioners, again, thanks for the opportunity to be here. We're going to call our next witness, Ms. Blair Wade, who is testifying remotely.
Okay, we'll recognize Ms. Wade, and Ms. Wade, please stand by to be sworn in by the court reporter.
Yes, ma'am.
If you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Mr. Walsh,
Okay.
Please go ahead.
Thank you, Chair Belser. Ms. Wade, good afternoon. Please first just state your name and your business address for the record.
My name is Elizabeth Blair Goodman Wade, and my business address is 4400 Leeds Avenue, Suite 450, North Charleston, South Carolina, 29407.
And where do you work?
I work at HDR Engineering.
And what are your responsibilities? What is your title at HDR Engineering?
I am our Southeast Renewable Energy Lead, and I'm responsible for working with our engineering and environmental teams to execute renewable energy projects for our clients. I'm also a senior environmental project manager and an associate within the company.
And even though I'm familiar with HDR Engineering, not everybody might be. Can you describe what is HDR Engineering?
Sure. HDR is a global firm that specializes in engineering, architecture, environmental, and construction services. And we provide these services for a variety of different infrastructure projects. Thanks.
I don't want to ask you about your entire professional background because I think you'll provide some of that later in a summary of testimony. But I just want to confirm, is all of that in your CV that's been provided as an exhibit in this matter?
Yes, it is.
Okay. Based on your background and all your credentials, do you consider yourself an expert in your field?
Yes, I do.
Ms. Wade, are you the same Blair Wade who caused direct testimony to be pre-filed in these proceedings on or about March 4th, 2022, consisting of 12 pages?
Yes.
And are you the same Blair Wade who caused amended and supplemental direct testimony to be pre-filed on May 25th, 2022, also consisting of 12 pages?
Yes, that's correct.
Okay. And were both sets of your testimony prepared by you or under your direction?
Yes.
And do you have any corrections, changes, updates to either sets of your testimony?
I do.
And what are those?
Since our testimony was last filed on May 25th, 2022, we did receive the nationwide permit authorizations from the U.S. Army Corps of Engineers. Those were received for both projects on July 1st, 2022. We've also received notice from the South Carolina Department of Health and Environmental Control, or SC DN, that we anticipate getting our 401 water quality certification concurrence later this week.
And so, and just for the staff, for technical purposes, I don't need to split screen. Ms. Wade, just stand by. I'm going to share my screen and show you a couple of documents. I will flip between them, and then I'll return to the examination, and I'll ask you a few questions about them, okay? And Ms. Wade, can you see my screen?
Yes, I can.
And if anybody cannot see this document, which is a see my screen, please advise.
Mr. Walsh, we can see it, but just realize we can only see about a third of it at the time.
I understand, Chair Belzer. Thank you. And now I'm going to switch to another document that looks very similar. Ms. Wade, the question's simple. Do you recognize what those documents are?
Yes, those are nationwide permit authorization letters from the U.S. Army Corps of Engineers.
And that's one permit for each project at issue in this hearing?
That's correct. That's nationwide permit 51 authorization, which is for land-based renewable energy facilities.
And you sort of anticipated my next question. I just want to ask a handful of questions before we get to your summary, just to flesh out what that is. Members of the commission come from all different backgrounds. Many lawyers aren't environmental lawyers either. A nationwide permit, what is that?
So the U.S. Army Corps of Engineers issues nationwide permits. They're usually on a 5-year cycle. And there are a series of permits under Section 404 of the Clean Water Act, as well as Section 10 of the Rivers and Harbors Act, that are intended for projects with minimal permanent and cumulative impacts.
And so in this case, both Lambert 1 and Lambert 2 now have this permit under the Clean Water Act, correct?
That's correct.
Is that important?
It indicates from the Corps that both of those projects meet the conditions and the thresholds of nationwide permit 51, which is, like I mentioned previously, for land-based renewable energy facilities.
Okay. And because the projects now have these permits, is that important for the progression of the projects going forward, and in what ways?
It is. It authorizes the applicant to impact a minimal amount of stream and wetlands in order to construct the projects. And then it also triggers the South Carolina Department of Health and Environmental Control, as well as their Office of Ocean and Coastal Resource Management, or OCRM, to issue their certifications and their consistency letters.
In 404 permitting, in Clean Water Act 404 permitting, we've just talked about nationwide permitting. And in contrast, there's such a thing sometimes referred to as an individual permit. Are you familiar with that term?
I am.
Is it fair to say that that an individual permit is needed when impacts are greater?
That's correct. An individual permit is needed when impacts are greater than typically half an acre, which is the threshold for nationwide permits. So then an individual permit would be required, or if the project does not meet general or regional conditions of the nationwide permit program.
And so based on that, is it fair to say that these projects received nationwide permits because wetlands impacts have been mitigated?
It is fair to say that these projects have received these nationwide permit authorizations because their impacts are less than the thresholds within the nationwide permit program, and that they are being mitigated in concurrence with the Corps regulations.
Quickly, there was a little bit of testimony earlier about how mitigation is undertaken or completed. So generally, as I understand it, it can either be through purchasing credits or through on-site mitigation. Is there a regulatory preference for one or the other?
There is. In the 2008 mitigation regulations that were brought forward by the U.S. Army Corps of Engineers, as well as the U.S. EPA, they have a mitigation hierarchy in which applicants are intended to go first to mitigation banks to seek mitigation for their project impacts. And then the subsequent mitigation options are what's called an in lieu fee program or permittee responsible mitigation, which is more of the on-site mitigation. So it's the Corps as well as the EPA's preference to do mitigation banks or to use mitigation banks first.
And is that the mitigation plan that is been provided to the Corps of Engineers? Is that the one that's selected here?
Yes, it is. We
All
are
right, so
planning to purchase, the applicant would purchase credits from an available mitigation bank.
Okay. Very quickly, I'm going to pull up one other document, Ms. Wade, again. I'll pull it up, I'll share my screen, and I'll just put it up for a moment so you can see it. And I might ask one question while it's still up, okay? Ms. Wade, do you see a document on your screen?
I do.
And do you recognize what that is?
Yes, that is our the siting and zoning plan for the project.
Looking at the top of it, I see what appear to be the initials HDR. Is that right?
That's correct.
And in fact, that's the firm that you work for, right?
Yes.
And this is the most current and up-to-date site plan for the Lambert 1 and Lambert 2 sites. Is that correct?
Yes, it is.
Just to give the commission a little bit of context, generally, can you describe where the cutoff is or where the separation is between the two projects?
The Lambert 1 solar project is located in the approximately the southern half of this layout. And then the Lambert 2 solar project is located in the northern part of the site.
Okay, thank you.
And that aligns with our nationwide permit authorizations.
Okay, thank you. Ms. Wade, returning to your pre-filed testimony, if I now asked you the same questions that are set forth in that pre-filed direct testimony and amended and supplemental testimony, would your answers from the stand be the same today, except for the corrections and updates?
Yes, they would.
Okay. Chair Belzer, at this time, the applicants asked that the pre-filed direct testimony, and second, the pre-filed amended and supplemental testimony of Ms. Wade be entered into the record for each docket, that is 93 and 97, as if given orally from the stand.
Ms. Wade's pre-filed direct from March 4th will be entered into the record as if read from the stand. Ms. Wade's amended and supplemental direct dated May 25th, 2022 will be entered into the record as if given orally from the stand. And I would note that because this is a combined hearing for both dockets, it is in the hearing and both dockets are covered.
All right, thank you, Chair Belzer. Ms. Wade, in your pre-filed testimony, both in the initial direct and in the supplemental, did you have exhibits attached to them?
Yes, yes, we did.
And are you familiar with all those exhibits?
Yes.
In your direct testimony, I just want to go through the list very quickly. You had your CV was attached to the direct testimony, a permit matrix, a critical issues analysis, a phase 1 environmental assessment, a cultural resources assessment, a U.S. Fish and Wildlife Federal Listed Species Effect Letter, a federal listed species effect memorandum, and a South Carolina Department of Natural Resources Species Effect Letter. Does that sound right? Those are exhibits 1 through 8 as numbered in your initial direct testimony. Does that sound right?
Yes, that's correct.
In your amended and supplemental direct testimony, Ms. Wade, you also had exhibits. As Exhibit 2, you had an updated permit matrix. Is that right?
That's correct.
So a similar document from your first testimony, but just updated to reflect the status of all the permits that day, as of May 25th.
Yes, that's correct. We update the permit matrix continuously throughout the project as permit needs change or as we receive permits.
Moreover, you also, as Exhibit 3 and Exhibit 4 to your supplemental testimony, you had a Clean Water Act Section 404 pre-construction notification. And as Exhibit 4, you had a Coastal Zone Consistency Certification request. Is that right?
That's correct.
Now, the pre-construction notification under 404 is sort of overcome by the fact that the permit's now issued. Is that right?
That's correct. The pre-construction notification is basically the application for the nationwide permit authorization.
But the application has all the information that the Corps of Engineers would use in making their permit decision, right?
That's correct.
A Coastal Zone Consistency Certification request. Quickly, what is that?
It is a request that goes to SC DN OCRM to have them review their project in light of the Coastal Zone Management Act. And it includes a cover letter, a copy of our pre-construction notification, as well as their Coastal Zone Consistency checklists that are applicable to the project.
Chair Belzer, at this time, the applicants asked that the exhibits referred to and incorporated in Ms. Wade's pre-filed direct testimony and amended and supplemental testimony be admitted into evidence. I've listed those exhibits. Moreover, we would also ask that the nationwide permits that Ms. Wade identified and testified about and that were filed in this docket yesterday be admitted into the record as well. As far as how to number those, I mean, I'm glad to do so afterward with the court reporter. I won't be referring to them individually at this point, but we can number them in order during a break.
Thank you, Mr. Walsh. We'll take care of that right now. Hold on just a second. ORS, any objection to these exhibits?
No objection, Madam Chair. I would say, just from a clarification or clarity of the record standpoint, I believe that Mr. Adams had already included the entire application as exhibit numbers 5 and 6. And so I believe, and I certainly stand to be corrected, but I believe that Ms. Wade's exhibits to her direct testimony would have already been entered into the record as exhibits number 5 and 6.
They are, but for clarity's sake, we're going to do them individually so that I think for referencing, I doubt if there'll be much reference to 5 and 6 in any proposed order. So,
yes, ma'am. Not a problem.
Thank you for that. Okay. Ms. Wade's pre-filed exhibits 1 through 8 that were attached to the original direct testimony will be marked for identification as hearing exhibit number 7 and entered into the record of this case. Ms. Wade's exhibits 1 through 4, which were pre-filed with the amended supplemental direct filed May 25th, will be marked for identification as hearing exhibit number 8 and entered into the record of this case. And the Corps of Engineers CWA nationwide permit verification for Lambert 1 and Lambert 2 will be a combined exhibit also marked for identification as hearing exhibit 9 and entered into the record of the case. Mr. Walsh, does that cover all of the exhibits you were offering at this time?
It does, yes, ma'am.
Okay, thank you.
Ms. Wade, have you also prepared a summary of your pre-filed direct testimony and amended and supplemental direct testimony?
Yes, I have.
And again, to be clear, does this one summary cover both projects?
It does.
And can you provide that summary to the chair and the members of the commission?
Yes, I will.
All right, thank you.
Good afternoon, Chair Belzer and members of the Commission. Thank you for the opportunity to speak with you today about these important projects. I am providing testimony in support of Silicon Ranch's applications for a Certificate of Environmental Compatibility and Public Convenience and Necessity for 2 solar projects to be located in Georgetown County, South Carolina. My testimony demonstrates that the Silicon Ranch Lambert projects meet key statutory requirements for issuing a CEC PCN. In particular, I focus on the environmental elements described in South Carolina Code Title 58, Chapter 33. First, I discuss studies which have been made by or for the applicants concerning the environmental impact of the projects. Second, I also address the findings of those studies and the project's compliance with environmental laws. I will address each of these areas in summary now. Based on that information, my testimony shows that environmental permits have been obtained, are under agency review, or applications will soon be completed. Based on the minimal environmental effects of the project and our agency coordination, I anticipate the applicant will successfully obtain all permits. I am the Southeast Regional Renewable Energy Lead for HDR, as well as a Senior Environmental Project Manager and Associate within the company. I and HDR have been providing environmental services for the proposed Lambert 1 and Lambert 2 solar projects since 2019. In addition to my education, I have 18 years of experience in environmental permitting and natural resources planning. My practice has an emphasis on working in renewable energy projects throughout the Southeast. A copy of my resume is provided as a part of this supplemental testimony. As you've already heard, the Lambert 1 and 2 sites encompass about 2,000 acres in Georgetown County, South Carolina, south of the town of Andrews and east of the unincorporated Lambert community. Based on historic aerial imagery and U.S. Geological Survey topographic maps, the project sites have been in silviculture for over 50 years, including up to the present, with large portions of the site having been timbered. The applicants, with the assistance of HDR, have performed the environmental assessments, studies, or analyses set forth in the project's permit matrix. A prior version of the permit matrix was previously provided, and an updated version is available and may have already been provided to you. As indicated in the current permit matrix, the following federal and state environmental permits, consultations, and certifications are complete or in process and include the Clean Water Act, Section 404, Nationwide Permit 51 from the U.S. Army Corps of Engineers, the Clean Water Act, Section 401, Water Quality Certification from the South Carolina Department of Health and Environmental Control, the Coastal Zone Consistency Certification from SC DN, Office of Ocean and Coastal Resource Management, the National Historic Preservation Act, Section 106 consultation with the South Carolina Department of Archives and History, and the Endangered Species Act, Section 7 consultation with the U.S. Fish and Wildlife Service, as well as the State Natural Heritage Database consultation with the South Carolina Department of Natural Resources. The following permits are also required and will be obtained by the applicant and their contractor prior to construction. And that includes the Clean Water Act National Pollutant Discharge Elimination System, or NPDES, a general permit, which is for stormwater discharges from construction activities. And that's from the South Carolina Department of Health and Environmental Control, as well as the land disturbance permit that is through Georgetown County. These permits also require the Coastal Zone Consistency Certification from South Carolina DHEC, Office of Ocean and Coastal Resource Management. So a quick review of some of the key permits and consultations. First, the applicants using HDR completed project review forms for the proposed project area pursuant to Section 106 of the National Historic Preservation Act. The forms were submitted to the South Carolina Department of Archives and History, which is a designated office for Section 106 consultation. Based on the recommendation from the South Carolina Department of Archives and History, HDR completed a cultural resource assessment for the site, which determines that there were no eligible sites on the project area. The South Carolina Historic Preservation Office confirmed and agreed with those findings and conclusions. I also wanted to provide the Commission with an update regarding the Clean Water Act, Section 401, or 404 and 401 wetlands permitting. As required, the applicants completed a wetland delineation for the project area, which has been submitted as part of the nationwide permit pre-construction notification to the U.S. Army Corps of Engineers. On July 1st, we received verification from the Corps that the proposed projects are authorized by Nationwide Permit 51, which is for land-based renewable energy projects. The Corps also indicates that they plan to issue a delineation concurrence for both sites. As approved by the Corps, wetland and stream impacts in the proposed mitigation are now well understood and mitigated to the point that the Corps has granted the nationwide permit. As indicated in the recently issued permits, the Lambert 1 project is expected to result in only 0.165 acres of permanent wetland impacts and 69 linear feet of stream impact. The Lambert 2 project is expected to result in only 0.294 acre of permanent wetland impact. To obtain these nationwide permits, Silicon Ranch has revised its design in numerous ways to greatly minimize impacts to wetlands. When considering these impacts, it's important to recall the past and the current use of the project area. On this site, the wetlands have been heavily utilized for silviculture for many years, and the wetland hydrology, soils, and vegetation have been impacted during that time. The project impacts to wetlands are minimal, and remaining wetlands will be allowed to revegetate or remain forested with only occasional hand clearing to prevent the shading of the adjacent solar panels. Based on the studies and permits issued for the projects and provided to the Commission, we can now say with confidence that the projects will have no significant environmental impacts. The projects will provide clean, renewable power with minimal environmental effects. A planting plan is currently being prepared that will utilize non-invasive native vegetation, including plants that attract pollinator species, as well as the monarch butterfly, which is a candidate for listing on the Endangered Species Act. The planting plan uses recommendations that are found in the South Carolina DNR Solar Habitat Guide. Vegetation and land management practices will be used to increase the overall biodiversity of the site, as well as the conditions of the soils. Silicon Ranch uses their standard specification for wildlife fencing, or for fencing, is a wildlife fencing with large holes on the bottom, which will allow for the passage of small mammals and other animals through the site. Plantings and a 200-foot wide buffer will be used to screen the panels from adjacent houses, minimizing the potential for visual effects. While minor short-term noise and air quality impacts may occur during construction, they will be comparable to the noise and air emissions that are generated by timber activities currently being conducted on the site. Once the facility is operational, there will be no permanent noise or air impacts to the surrounding area. Based on the minimal environmental impacts, I believe there are no conditions which should adversely affect the project's ability to obtain permits needed to maintain environmental compliance. Potential impacts are well understood and will be mitigated in accordance with regulatory requirements. My testimony shows that the projects will also have environmental benefits. Accordingly, from an environmental standpoint, I believe the Commission can follow the lead of the Corps, as well as the other environmental agencies, and approve these projects. Thank you. Oh. Court, I think you're muted. I can't hear you.
Mr. Walsh?
Boy, I just said the most brilliant things that I've said all day. I have to remember them again. Thank you, Ms. Wade, for that summary. Chair Belzer, Ms. Wade is available for questions on cross-examination or from the commissioner or whomever.
Thank you, Mr. Walsh. Office of Regulatory Staff?
No questions.
Thank you. Commissioners? Vice Chair Powers?
Thank you, Madam Chair. Ms. Wade, how are you this afternoon?
I'm doing well, sir. How are you?
I'm good. I guess because of my background, all the wetlands really concern me, and I would like to say that as a former member of the Board of Ocean Resource Coastal Management and the prior Coastal Council, would you believe me if I said that we didn't always agree with the Corps of Engineers?
Yes, sir, I would.
And my real concern is, who's going to keep all this construction waste out of these wetlands?
One of the conditions of the nationwide permit program, and that's specifically outlined in the authorizations provided by the Corps, is that the applicant follows the state's best management practices related to construction, and that they have to put in appropriate erosion and sediment control and have to commit to not impacting these wetlands either permanently or indirectly during construction. And so those are measures in which the applicant must follow in order to remain in compliance with their permit.
Well, as wet as this area is, and just knowing the impact that storms have in South Carolina, certainly more than Georgia. Storms seem to go Florida or skip Georgia and come hit us or the Outer Banks. As far as flooding, if there's significant flooding, would that affect the ability of the solar panels to operate?
None of the solar panels that are proposed on the site are located in FEMA floodplains, and the site has been designed to avoid the highest areas of inundation on the property. So really to avoid the lowest areas of the site. The project is designed to withstand some level of inundation underneath the panels, but it's been sited such so that that should not be a problem for operation.
Okay. Well, when we have significant storms, and I think you've heard Hugo mention, and you may not be familiar with that storm, a storm like that would likely just wipe this area out. What sort of interconnection, or what would it be to provide power if the solar system is wiped out by a storm?
I'm not sure if that's something that I can answer. That would be more of a question for the applicant or a question for the utility.
Okay. Well, the applicant has complete ownership and operation of the facility. If the facility is knocked out, the applicant would not have any sort of alternative to provide power, would they?
As part of the applicants, as previously mentioned, with their insurance, as well as their own, their operations and maintenance plans, I mean, they monitor these sites regularly. And so if there was a portion of the site that was impacted by a storm, that would be their responsibility to fix and bring that system back online again.
Well, let's say you had significant, more than 50% damage to the area or to the solar panels. How long would it take to make such a repair to get back up and online as far as providing power?
I'm sorry, sir. That's outside of the scope of the work that I'm doing for Silicon Ranch Corporation. That'd be something I'd have to ask Mr. Eccles about.
Well, we asked some questions and they kept sending them to you. Okay, well, thank you, ma'am. Thank you very much. Thank you, Madam Chair.
Thank you.
Thank you, Vice Chair. Commissioner Thomas.
Thank you. And good afternoon, Ms. Wade.
Good afternoon.
So I've had a little bit of experience working with OCRM and the Corps of Engineers, and I'll just have to say you have a complicated job. But there's one thing in your testimony that you mentioned that I had a question about. And you said there's one site eligible for the National Register of Historic Places in the buffer area. Can you give me a little bit more information about that? What is that, and what may become of that in the future?
Yes, I believe on the South Carolina Department of Archives and History, on their web-based database, which is called ArcSite, there was a previously recorded site that was within a half-mile buffer of the project site. It is not on the project site and would not be impacted by the project. And so as far as what would happen to it in the future, I don't know if there's anything that the applicant would have any control over that. It's something that anybody that was working within proximity to would need to consult with South Carolina Department of Archives and History about.
So it's not on the property that's owned by the Lambert 1 or 2, it's adjacent to, is that what I'm hearing?
That's correct. When we do our consultations with the State Historic Preservation Office, we typically put a half-mile buffer around the project site to see if there's been any recorded archaeological or architectural sites within proximity to the project. So it's not on the site.
Okay, thank you. That's all I had.
Thank you.
Thank you, Commissioner Thomas. Commissioner Caston.
Good afternoon, Ms. Wade.
Good afternoon.
I haven't forgotten you. I'm just looking for you. There you are. If I understand correctly, going back to the permitting, nationwide permit was issued because there was less than a half acre disturbed of less than a half acre of wetland disturbed. Is that correct?
That's correct.
Not 1.34 acres.
The nationwide permit can be used for projects that have less than a half an acre of permanent impacts and meet the general and regional conditions. The project, as applied for, has 0.165 acre of permanent wetland impact for Lambert 1 and 0.294 for Lambert 2.
Okay. And you probably answered this multiple times, but on page 5 of the application, certification of environmental compatibility, HDR further recommends additional analysis, which has been done or is in the process of being completed. Have all those additional analyses been completed?
Yes, sir. We've completed all of the required analyses and applications for the project so far.
So nothing remains to be done relative to that?
No, the only application that remains to be done is related to the stormwater permit with the state, as well as the land disturbance permit with Georgetown County and the associated coastal zone consistency for both of those.
What do you know off the top of your head? What are the ranges of ground elevations of those sites? Do you know?
I don't know the elevation off the top of my head. Obviously, it's Georgetown County, so it's the low country. But it is a very flat site. There's not a lot of topographic relief on the property.
They call it the low country for a reason, don't they?
That's right.
Did HDR look at, I guess with that in mind, like look at historical storms, storm surges, such as that, relative to siting and the facilities and such as that?
We did do a preliminary hydrology analysis for the site, and that's ultimately something that will have to be done as part of the preparation of the stormwater pollution prevention plan that goes in with the stormwater permit applications. It's not in the zone of Georgetown County that would require a storm surge analyses, but we did look at which areas of the site would be inundated during certain intervals of rainfall. And the panels are sited as such to avoid those areas of the highest inundation.
So you looked at the rainfalls based on the requirements for the stormwater permit, not necessarily what historical storm surges may or may not be. Or
We looked at the intervals that are required by both the county and the state, correct?
okay. And I'm not sure what detail HDR was involved with the solar panels, or I guess the arrays themselves, but are these things typically hardened or designed to withstand significant storms, such as hurricane storm surges or, microbursts or things such as that?
Part of the design of a solar facility is to look at the structural elements of a solar site. And so a structural engineer will provide input into the size and the material type and specifications of the steel H piles that support the solar panels. That is not part of HDR's scope, but it is a component of the project design, is to look at the structural integrity.
So this particular site, you say they're using piles. Is that what I understood you to say?
Yes, sir. The solar panels are supported by steel H piles.
I think that's all I have. Thank you, Ms. Wade.
Thank you, sir.
Thank you, Commissioner Caston. Other questions from commissioners? Commissioners? Hearing none. Mr. Walsh, any redirect?
Chair Belzer, no redirect from the applicants. Thank you.
Thank you, Mr. Walsh. Ms. Wade, thank you for your testimony today. You may stand down.
Thank you.
Mr. Walsh, please call your next witness.
Certainly. Thank you, Chair Belzer. At this time, we are going to call Mr. Kenneth to testify, and he's also testifying remotely.
Mr. Walsh, I think I know who you're calling, but there was kind of a break or transmission glitch there. Could you repeat that, please?
Certainly. We're calling Mr. Kenneth Searcy is our next witness. Kenneth, are you there?
Yes, I'm here.
Okay. Mr. Searcy, please hold for a moment to be sworn in by the court reporter.
Mr. Searcy, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Mr. Searcy, please state your name and business address for the record, please.
Sure. Kenneth Searcy, 1625 Q Street Northwest, number 101, Washington, D.C. 20009.
And what is your work?
I am employed at Searcy Consulting. I'm an independent consultant doing data analysis and energy modeling, as well as market research, specifically in the power sector, and expert witness testimony, like in this case.
And speaking of expert testimony, you've testified before this commission previously, right?
That's correct. I testified in a Dominion IRP proceeding, a Dominion avoided cost proceeding, and then a competitive procurement of renewable energy proceeding.
So even though the commission is probably a little bit familiar with your background, could you kind of briefly give them an overview of what your professional and educational background is?
Sure. So, got a bachelor's from Clemson. I've got a master's from Duke University, where I did coursework in engineering, economics, and finance with the thematic focus on power systems. After the master's program, went to work as the South Carolina Coastal Conservation League's utility regulation specialist, where I managed the Conservation League's work before this commission in over 60 proceedings from 2012 to 2018. In 2018 is when I started Cersei Consulting and started the work that I just mentioned for renewable energy companies, renewable energy trade groups, larger consulting firms, and environmental groups.
And any additional information about your background, that's going to be contained in your CV that was attached as an exhibit to your testimony.
That's correct.
And do you consider yourself an expert in these fields?
I do.
And you're the same Kenneth Cersei who caused direct testimony to be pre-filed in these proceedings on or around March 4th, 2022, consisting of about 20 pages, right?
That's correct.
And that testimony, was it prepared by you or under your direction?
Yes, it was.
Do you have any corrections or changes to your testimony?
Just the business address that I just gave. It's updated since the pre-filed testimony.
Mr. Cersei, in your testimony, very quickly, you cited to various reference documents. Is that right?
That's right.
And among them, the 2020 Santee Cooper IRP, the 2020 Central Electric IRP, and another document titled the Santee Cooper Reform Plan. Are you familiar with those documents?
Yes, I am.
And again, to be clear, those are explicitly cited to and referenced in your direct testimony that was previously filed in March?
That's correct.
Okay. And are those the same documents? Do you understand that those are the same documents that were filed with the commission? The full copies were filed with the commission recently?
Yes.
And do you consider those documents to be a part of your testimony?
I do, yes.
Mr. Cersei, if I now ask you the same questions that are set forth in your pre-filed direct testimony,
Mr. Walsh, you're very low. Can you start that again, please? It was very hard to hear the first part of that question.
I'll move a little closer. Thank you. Mr. Cersei, if I now ask you the same questions that are set forth in your pre-filed direct testimony, would your answers from the stand be the same today?
Yes, they would.
Chair Belzer, the applicants asked that the pre-filed direct testimony of Kenneth Cersei be entered into the record for each docket as if given orally from the stand.
Mr. Cersei's pre-filed direct, with the correction noted to his address, will be entered into the record as if read from the stand.
Moreover, Madam Chair, the applicants asked that the exhibits referred to and incorporated in Mr. Cersei's pre-filed direct testimony be admitted into the record. Those exhibits being, first, Mr. Cersei's CV, his resume, and also the three reference documents that he just described in his live testimony, those being the Santee Cooper IRP, the Central Electric IRP, and the Santee Cooper Reform Plan.
ORS, any objection?
No objection.
Mr. Walsh, I have a question as to why these documents that were referenced in his testimony were not provided as exhibits at the time his testimony was pre-filed.
Chair Belzer, really, I think just for, they're publicly available records. At the time I thought that would be sufficient. And having at least discussed it with ORS, I believe that they have also referred to the same documents in preparing for today. So based on their public availability and their explicit reference in his testimony, basically to be abundantly cautious, we wanted to make sure that they were in the record though in full
Okay.
for consideration.
We will accept these today, but please realize that there are pre-file dates that are set. And usually when documents are coming in or being filed after that, there need to be accompanied by a motion. So please keep that in mind for the future.
Thank you, Chair Belcher. I appreciate that.
Okay. Mr. Searcy's CV, which is attached to his direct testimony, will be entered into the record as hearing exhibit number 10. Just a second while I consult with the court reporter, please. All I'm asking the court reporter is, due to the size of these exhibits, does she want them a compilation exhibit or separate? That's what I'm asking her. Okay. We're going to enter them separately so that the PDFs are not too big here. So the CV is marked for identification and entered into the record as hearing exhibit 10. The Santee Cooper Reform Plan will be marked for identification as hearing exhibit 11 and entered into the record. The Central Electric's 2020 IRP marked for identification as hearing exhibit 12 and entered into the record. And Santee Cooper's 2020 IRP marked for identification as hearing exhibit 13 and entered into the record. Does that cover all of them, Mr. Walsh?
Yes, it does, Chair Belcher. Thank you.
Thank you. Please proceed.
Thank you. Mr. Searcy, if you also prepared a summary of your pre-filed direct testimony.
Yes, I have.
And Mr. Searcy, if you're ready, please provide that summary to the commission, please.
Sure. Good afternoon, Chair Belser and members of the commission. I am providing testimony in support of Silicon Ranch's application for a certificate of environmental compatibility and public convenience and necessity for 2 solar photovoltaic projects to be located in Georgetown County, South Carolina. Silicon Ranch is an experienced large-scale solar power producer with thousands of megawatts of solar PV capacity in operation and development, including in other southeastern states. My testimony demonstrates that the SR projects meet key statutory requirements for issuing a CEC PCN. I focus on 3 elements described in South Carolina Code Title 58, Chapter 33. First, I discuss the basis of the need for the facility. Second, I address the project's contribution to system economy. And third, I discuss how the projects serve the interest of system reliability. I will address each of these 3 areas in summary now. Beginning with the need for the facilities, there is demand for solar energy in South Carolina. Specifically, utilities Santee Cooper and Central Electric Power Cooperative have engaged in long-term planning efforts that identified large-scale solar photovoltaic technology as part of the best mix of resources to meet customer needs at a reasonable cost. Further, the utilities acted on these findings by issuing a request for proposals, or RFP, for solar energy, which resulted in a competitive field of 56 project bids, totaling 3,600 megawatts of capacity. Santee Cooper and Central awarded contracts for 425 megawatts of capacity, and 2 of the project awards went to the SR projects at issue in this application. Long-term power purchase agreements have been executed for the projects as well. Turning to the topic of system economy, my testimony concludes that the SR projects improve the economic performance of the Santee Cooper and Central systems. I discussed several detailed long-term resource planning studies conducted by the utilities that compare alternative resource plans using industry standard software tools, as well as sensitivity analyses that tested the plans across a range of potential future conditions, such as load growth and fuel prices. These economic analyses found that adding hundreds of megawatts of solar PV in the near term is part of a cost-effective mix of resources for meeting customer demand. These results are in line with industry trends, whereby utilities, both regionally and nationally, are finding renewable energy resources to be cost-competitive additions to supply portfolios. My testimony also concludes that the SR projects serve the interest of system reliability. I draw on detailed reliability analyses conducted as part of the Santee Cooper and Central resource planning efforts. First, both utilities employ reserve margin constraints in their studies that ensure that the alternative plans evaluated are capable of meeting peak demand each year, even under abnormally high load conditions or with a forced outage at a generating unit, including the plans the utilities selected featuring significant solar PV additions without paired storage. Second, the utilities also found that hourly solar variability from the amount of solar evaluated would not adversely impact system reliability. For example, Santee Cooper performed an operational analysis using an hourly chronological dispatch simulation to assess the impact of solar variability on the system's ability to balance supply and demand and thus maintain reliability. The study identified no significant reliability issues. These findings are also consistent with industry experience, again, both regionally and nationally, demonstrating that modest levels of solar PV do not pose substantial reliability challenges. In summary, my testimony demonstrates that there is a need for the SR projects in South Carolina, that the projects have been compared to other generation options in terms of cost and reliability, and that they serve the interests of system economy and reliability. I believe that the public convenience and necessity require the construction of the SR projects, and I recommend that the Commission grant the SR projects CEC PCN. Chair Belser and Commissioners, this concludes my testimony summary, and I'm happy to address any questions you may have.
Mr. Walsh, you tender the witness.
Thank you. Yeah, Mr. Searcy, thanks for the summary. Chair Belser, Mr. Searcy is available for questions from other parties.
Thank you, Mr. Walsh. Office of Regulatory Staff.
No questions.
Thank you. Commissioners. Commissioner Vice Chair Powers.
Thank you. Mr. Searcy, good afternoon. And I really just have one question. I'm familiar with your earlier work with the Coastal Conservation Group. And would your testimony and opinion be the same if you were here presenting on their behalf today?
Yes, it would be. I think my testimony is based on the studies that I cite and the economic and reliability analyses that are contained in those studies and the technical results, which show that solar PV added to those systems improves the economics and contributes to the reliability. And so I think that I would have those conclusions regardless of who I was appearing on behalf of.
Okay. You feel that the mitigation credits and the importance of solar energy outweighs any damage to these wetlands?
Vice Chair Powers, the mitigation credits are really outside of the scope of what I'm testifying to in this proceeding.
Okay. Thank you, sir.
Thank you, Commissioner.
Thank you, Vice Chair Powers. Commissioner Caston.
Afternoon, Mr. Searcy.
Good afternoon, Commissioner.
I'm waiting, I guess, looking at, the system reliability part, making sure I understand that, just for my edification, no other reason. Talking about, I think it starts on page 14 of your direct testimony. And you went through the reliability analysis. And I want to make sure I understand. As I understand it, Santee Cooper, I think, intends to retire some generation units, I think coal units, and replace with 500 megawatts of solar. Is that correct?
Well, mostly, Commissioner. I think I would say that a little bit differently, though. I think the way that I would say it is that Santee Cooper has a going forward resource plan that includes both retiring some coal units and adding 500 megawatts of solar, but it also includes other actions.
Like other generation actions, or is that what you mean?
Right, other generation actions. I believe it's a 15-year plan. And so there's a variety of resources that are being added. One of them is the solar. Some of the coal is being taken off. And then the majority of the existing resources, the other coal on the system, the gas-fired resources that are on the system today, VC Summer, Santee Cooper's share of VC Summer, the hydro that's on the system, generally speaking, all of that stuff is staying.
Okay. And that probably gets me to, I guess some of the questions are relative to, well, like you said, first, the candidate plans that Santee Cooper evaluated, incorporated summer and winter reserve margin constraints, plus reserve margin or buffer to ensure under abnormally high load conditions, forced outage generating until the system there, is that Santee's system as a whole? Is that what the system is? Okay.
That's exactly right. Santee's system as a whole. So all of the power plants acting together, they're all hooked up to the transmission system. They're all connected as one. Transmission system is also connected to the load. So everything is all connected together. And that's the system that I referred to there, correct?
Okay, because that's what I was trying to understand in going forward, whether with these two particular projects and those to follow, is it's part of their mix. But if I'm understanding what you're saying in this reliability analysis, that adequate dispatchable generation will exist to offset any generation retirements. Is that correct?
That's correct. Yes. So Santee Cooper and actually Central as well in their resource plan, what they have to do is they have to look at their system again as a whole, looking at all the different power plants on the system. And when they create a plan that they're going to consider, a resource plan to meet their customers' needs over the long term that they're going to consider and compare to other possibilities, what they have to do is they have to ask the question, can this plan supply our customer needs every hour of every year and across all of the different types of weather that we see in South Carolina? Not only that, but could the plan do that and also be okay if one or two or maybe even a few of those units had a forced outage and all at the same time? So they have to ask that question when they create plans that they're going to compare against one another. So every one of their plans that they considered, they made sure that it can do that. It can meet demand at all times through all types of weather. And so that includes then the plan that they ultimately selected, which is the one that we've been talking about, that retires a good chunk of their coal, but certainly not all of it, and adds 500 megawatts of solar. But it's standalone solar. It's not solar paired with storage, and that's okay because again, it's the system as a whole that you have to think about. No one resource by itself can meet all the needs, whether you're talking about solar or nuclear or coal or anything else. They can all experience forced outages. So it's the system as a whole that you have to look at. And that's what they do in their analyses. And so what I was saying in the testimony is Santee Cooper and Central, both in their IRPs, did that reserve margin analysis so that they ensured that they can meet reliability all the time.
Okay. And you're probably, I don't know if you're the one to ask this, but based on what you just said, would that, with whatever generation retirement that they're proposing, the coal retirement, and you've heard me ask questions and other commissioners ask questions about storms, does this reliability analysis or what you just described, if that storm did occur, because I think HDR, Ms. Wade talked about, the permitting process for stormwater, which, is based on rainfall events, not the hurricanes, storm surge events. If these systems, these solar arrays were out for an extended period of time from storm, and you had the coal retirement kind of already done, is that covered under this reserve?
Yes, Commissioner, that's exactly right. It is. So the system would be fine under that circumstance. Reliability would be maintained because of the way that Santee Cooper did their planning and the analysis that they did to ensure that that's the case.
And that would include the whole 500 megawatts of solar that they're looking at adding.
Exactly right. And the solar, by the way, is helping the reliability during the times that it's generating, right? I mean, it's generating during the day, and every megawatt hour that it's generating is supporting the system, which is especially important, during times of system stress, like hot summer afternoons. That's when solar generates the most, right? And it's also a time of system stress. And so it's helping reliability when it is generating. when it isn't able to generate, the rest of the system picks up the slack. And again, that's true of everything, right? Like that's true of VC Summer. VC Summer has forced outages, and when it goes out, the rest of the system picks up the slack. It's true of the coal units that are still on right now. They have forced outages. And when they do, the rest of the system picks up the slack. So it's true of all generation, and it's true of this this technology as well.
Well, that's why I'm asking these questions, because you've probably heard of Murphy's Law.
Sure, yeah. Which is exactly why these reserve margin analyses were created. It's been a core part of resource planning since IRP started back in the 80s. It's been there from the beginning.
Well, I can say that, at least from my experience, is that if all the worst stuff that can happen at the worst time, it can happen. Because kind of been there and done that. So that's the bulk of at least my question or concern, that it's, as I guess to move along in whatever direction Santee Cooper chooses to go, that when things happen, and they will, 24/7, 365 is pretty big demand, and that's all I wanted to ask. Thank you very much, Mr. Searcy.
Thank you, Commissioner.
Thank you, Mr. Commissioner Caston. Any other commissioners?
Chairman Belser?
Commissioner Carolee Williams?
Yes, thank you. Mr. Searcy, I just want to piggyback on Mr. Caston's or Commissioner Caston's questions, and there's feedback somewhere. Is it coming from me?
I'm not sure. I can mute while you're speaking if that might help.
Okay, I'll do the same. So perhaps you said this, but we're less up to speed with Santee Cooper and Central's composition. And so my question is, are they winter peaking or summer peaking?
They're both winter peaking. Although I think it's important to recognize that even if they experience their highest hour of load during the winter, and specifically they experience it during the winter mornings, they still experience very high loads in other times, right? I mean, like if you looked at the top 1% or the top 5%, a lot of it would be in winter mornings, but the rest of it would probably be summer afternoons. And so, you know, that gets to the point that during those winter mornings, you know, solar PV by itself with no batteries might not be generating that much, which just means that it doesn't have that much reliability value right then. But then in the summer afternoons, it's generating a lot. And the system is still under a lot of stress and has a risk of having an overall power outage. And so having generation in those times is really valuable. And so that's where solar PV, even without storage, is helping reliability greatly. And the sum total of all of it is that it's beneficial to reliability.
That answers it. Thank you very much. No further questions, Madam Chair.
Thank you, Commissioner Williams. Other commissioners? Mr. Searcy, I just wanted to clarify, in the Santee Cooper and Central studies that you've referenced in your testimony, you reviewed studies that they conducted. You didn't do independent studies, is that correct?
That's correct, Chair Belser.
And did you have access to any of the underlying data, or was your review based on the records that were just submitted into the evidence of the hearing?
They were based on the documents that we submitted into the hearing.
Okay. Thank you very much. It's good to have you with us again. Always look forward to your testimonies. Thank you for appearing. That's all I have.
Good to be here. I appreciate it.
Commissioners, anyone else? Mr. Walsh, any redirect?
Yes, Chair Belzer, I just have one or two questions. Mr. Searcy, there was some discussion before about wetlands impacts, and in response, you said that is not strictly within the scope of your testimony here. Is that correct?
That's correct.
Now, at the same time, you've been present during the entire hearing, listening to the testimony, correct?
Yes, I have.
And you're aware that there are wetlands impacts, is that right?
Yes.
And knowing that, that doesn't change your opinion. In other words, your opinion here today is that the projects will further public convenience and necessity. Is that right?
That is correct.
Okay. Thank you, Mr. Searcy. Chair Belzer, I have no more questions. And I have no more questions. Thank you.
Thank you, Mr. Walsh. Bear with me just a second, Mr. Searcy. ORS, any limited recross?
No, Madam Chair.
Commissioners, any questions? Thank you. Mr. Searcy, again, thank you for your testimony today. You may stand down. Mr. Walsh?
Chair Belzer, could I ask one follow-up question to Connor Eccles? Would that be possible at this point? It'll take one.
Is this Mr. Adams?
Yes, ma'am.
Okay. And who do you want to recall?
Connor Eccles.
Any objection?
No objection.
No objection. Please go ahead, Mr. Adams. Let's recall Mr. Eccles. Where's Mr. Eccles? There he is. You are still under oath. And Mr. Adams, you may proceed.
Yes, ma'am. Thank you, Chair Belzer. Connor, just one question. There have been some questions about hurricanes and flooding and the possibility of the system going out. Did the RFP that you guys responded to, did it mandate that you provide standby or backup power to the system? Are you required to have some other source of generation in addition to the system you're building, or were you just simply asked to build a solar array?
We were not mandated to provide a backup generation. It was just for the solar array.
So the RFP is purely for the solar array alone?
Yes, sir.
Okay. Chair Belzer, that's all I had.
Thank you, Mr. Adams. ORS, any cross-examination?
No question.
Commissioners, any questions? Hearing none. Thank you, Mr. Eccles. Thank you, Mr. Adams. Mr. Adams, anything further?
No, ma'am.
Or Mr. Walsh. I should recognize both of you there.
Now, I would like to take up the quick start motion again at some point, but we certainly could do that after ORS has presented its case.
Okay, let's finish with the testimony if you don't mind.
Sure.
Does that conclude?
I apologize.
Go ahead.
Yeah, and Chair Belzer, to dovetail off of Mr. Adams, I might even propose that we just take maybe a 2-minute recess, seeing as we've been going for a little while. This probably concludes our case in chief, our presentation, but with 2 minutes, I can confer with Mr. Adams and then we can move forward.
Okay, that's fine. Let's take a 10-minute break. We'll be back at 2:15. And thank you. I really hadn't realized that we've been going for an hour and 15 minutes. So thank you.
It's just that.
I'm sorry, 3:15.
I take it as a compliment.
We're going. We'll break until 3:15, not 2:15.
Thank you, ma'am.
Welcome back to the Public Service Commission as we continue the hearing in dockets 2022-93E and 2022-97E. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Jay Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Caston, Chair Belser, and with us virtually we have Commissioners Irvin and C. Williams. We are now at the point where the Office of Regulatory Staff is recognized for their case.
Madam Chair, certainly happy to. I believe before we broke, Mr. Adams and Mr. Walsh mentioned that they were going to confer.
You.
So
thank you. Thank you very much. Appreciate you keeping me straight. Mr. Adams or Mr. Walsh?
Yes, ma'am. No further witnesses from us. We would like to reserve literally 90 seconds to close and to address the quick start approval and after Ben is done with this case.
Thank you, Mr. Adams. Now ORS.
thank you, Madam Chair. We would call Mr. Anthony Sandinato and Mr. Michael Seaman-Wynn, who will provide the testimony as a panel.
Thank you, Mr. Seaman-Wynn and Mr. Sandinato. Please come forward.
And Madam Chair, do you have a preference as to which podium?
Let me check with the back. Is there a preference as to which podium? I think they prefer this one over here, Mr. Mustin.
Raise your right hands. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Mr. Sandinato, we will start with you if you don't mind. Please state your name for the record.
My name is Anthony Sandinato.
And by whom are you employed and in what capacity?
I'm employed by the South Carolina Office of Regulatory Staff as the Deputy Director of Energy Planning and Emerging Technology.
And Mr. Sandinato, in connection with this proceeding, did you prepare or cause to be prepared 7 pages of direct testimony?
Yes, I did.
Do you have any corrections, additions, or deletions to that testimony?
No, I do not.
If I were to ask you those same questions, would your answers be the same here today?
Yes, they would.
Madam Chair, I would ask that Mr. Sandinato's direct testimony be entered into the record of this proceeding as if given orally from the stand.
Mr. Sandinato's direct pre-file testimony will be entered into the record as if read from the stand.
Mr. Sandinato, have you prepared a summary of your direct testimony?
Yes, I have.
Okay. Could you provide that to the Commission at this time, please?
Certainly. Good afternoon, Madam Chair and members of the Commission. The purpose of my testimony is to set forth and support ORS's recommendations resulting from the examination and review of the applications of SR Lambert 1 and SR Lambert 2 for certificates of environmental compatibility and public convenience and necessity to construct separate 100 megawatt solar photovoltaic projects to be located in Georgetown County. My review focused on the basis of the need for the solar facilities and whether the solar facilities will serve in the interest of system economy and reliability. I reviewed the applications, direct testimonies of the company's witnesses, and numerous studies included in the applications, witnesses, exhibits, and discussed in testimony. Finally, ORS reviewed additional materials provided by the companies through discovery and conducted discussions with company representatives. The companies identified the need for the proposed facility based on both Santee Cooper and Central Electric's IRPs. Santee Cooper's 2020 IRP states that its preferred plan includes 500 megawatts of new solar generation added to its system by 2023. Central's 2020 IRP determined that adding 225 megawatts of solar to its system by 2022 was part of a long-term plan that was lower cost than the alternative plans evaluated by the utility. As part of the Santee Cooper reform plan submitted to members of the South Carolina General Assembly on November 25, 2019, Enfront Consulting conducted a resource planning study for Santee Cooper. Appendix A of the 2019 Resource Planning Study discussed the analytical methods and detailed information pertaining to the economic modeling results under a reference case and sensitivity case assumptions. The analysis found that including new solar generation resulted in savings on a net present value basis compared to the base case, where no solar generation was added. As described by witness Cersei, Santee Cooper issued a request for proposal for solar energy in June of 2020. SR Lambert 1 and 2 were among the 425 megawatts of solar energy projects awarded power purchase agreements by Santee Cooper and Central as part of the competitive RFP process. The executed PPAs are consistent with the analysis performed by Santee Cooper and Central, as well as the results of the summary of initial assessments of RFI submittal performed by Infront Consulting. In addition, there's been no request for an assessment of an independent evaluator as provided by Section 5833.110.8, which was part of Act 62, known as the South Carolina Energy Freedom Act. Therefore, an independent evaluation is not included in ORS's review. Based on the information provided by the applicants, ORS concluded the projects conserve the interest of system economy and reliability. This concludes my summary.
Thank you, Mr. Santinato. Mr. Seaman Wynn, could you please state your name for the record, please?
My name is Michael Seaman Wynn.
Okay, and by whom are you employed and in what capacity?
I am employed by the Office of Regulatory Staff as the Deputy Director of Energy Operations.
Okay. And Mr. Seaman Wynn, in connection with this proceeding, did you prepare or cause to be prepared 6 pages of direct testimony?
Yes, I did.
Okay. Do you have any corrections, additions, or deletions to that testimony?
No, I do not.
If I were to ask you those same questions, would your answers be the same here today?
Yes, they would.
Madam Chair, I would ask that Mr. Seaman Wynn's direct testimony be entered into the record of this proceeding as if given orally from the stand.
Mr. Seaman's direct pre-file testimony will be entered into the record as if given orally from the stand.
Okay. And Mr. Seaman Wynn, have you prepared a summary of your direct testimony?
Yes, I have.
Okay, please provide that at this time.
Yes. Good afternoon, Madam Chair and members of the Commission. The purpose of my testimony is to set forth and support ORS's recommendations resulting from the examination of the applications of SR Lambert 1 and SR Lambert 2 for certificates of environmental compatibility and public convenience and necessity to construct and operate 2 100-megawatt solar voltaic projects to be located in Georgetown County. I also addressed the proposed transmission facilities required to interconnect the solar facilities to the transmission grid. My review focused specifically on the impact of the projects, whether the environmental impact of the projects is justified, the reasonable assurances that the projects will conform to applicable state and local laws and regulations, and whether the public convenience and necessity requires construction of the projects. ORS reviewed the applications, the direct and supplemental testimony of the company's witnesses, and the numerous studies included with the applications. ORS reviewed additional materials provided by the companies through discovery and conducted discussions with companies' representatives. The Siting Act directs that an application contain a description of the location and the facilities to be built, a summary of any studies that have been made of the environmental impact of the facilities, a statement explaining the need for the facilities, and such other information as the applicant may consider relevant or as the Commission may require. The applications include a description of the projects, their locations, and descriptions of the intended use and need for the facilities. The studies, provided as part of the applications, indicate the projects will not have a significant impact on the environment and on cultural and land use resources. ORS believes the impact of the projects is justified. SR Lambert affirms through the applications and pre-filed testimony that the projects will conform to all applicable state and local laws and regulations. ORS's review concluded that the projects will result in minimal impact to the environment and, as addressed by ORS witness Santinato, will serve the interests of system economy and reliability. This concludes my summary.
Thank you, Mr. Seaman Wynn. Madam Chair, the witnesses are available for cross-examination and commissioner questions.
Thank you, Mr. Mustian. Mr. Adams or Mr. Walsh?
No cross from the applicants.
Thank you. Commissioners, questions? Commissioner Caston.
I think your last statement or so leads me to Mr. Santinato, so I'll go ahead and ask it, and then you can tell me.
Yes, sir.
Relative to system reliability and review of that, would I ask you that question or wait on Mr. Sandinato?
I believe Mr. Sandinato might be in a better place, but I'll be happy to add to anything that he may give you, sir.
Okay, we'll start there and then see where it goes, if that's what you wish. As you know, previously in my questions, I think with Mr. Searcy, hypothetical. The coal plant's been retired. Hurricane in November causes catastrophic damage to solar array. 2 months later, there's a winter vortex. Temps extreme cold. Is ORS confident that the utility will have reliable reserves to mitigate?
I'll take the first stab at that, Commissioner. In this hypothetical, the coal plants, yes, they are shut down, but we also know that Santee Cooper will need to replace that existing generation to ensure that it meets its reserve margin. And then also, as discussed by Witness Searcy, the replacement generation selected will then be needed to prove that it can meet every hour of system need on the system. So in that hypothetical, any replacement capacity with firm would need to be also replaced to ensure that the system's able to meet the reserve margin and provide electricity in that scenario.
All right, and I'm not trying to paint you in a corner here, but it sounds like you said that would need to be done, but you're not saying, yes, that is the case, that would be the case.
It's difficult because now we're moving into an IRP proceeding when we're looking at the selection of future resource, when here, as part of our review, is specifically for the siting of these 2 100 megawatt solar photovoltaic arrays, which is why there's some hesitancy.
I understand. And again, it wasn't a trick question. I'm not trying to hang you out to dry or anything on that. But I'm, serious when I'm saying I assume and hope utility thinks about this, and you guys do, is that no one can prepare for everything under the sun because you don't know what that is. But firsthand, I can tell you, if all the awful things can happen at the worst time possible, they will. And I was thinking about the solar vortex. If something like this happened, and perhaps part of the plan is to purchase power elsewhere, well, if there's that winter vortex here, there's a high probability it's not just here. It's probably not going to just perch right over South Carolina. It could, but doubtful. I think you've answered the question the best you could.
Yeah, and just to add, reliable, high-quality service is part of ORS's mission, and as part of all of our review and future proceedings, we ensure that that was the case for all of the utilities.
Good enough. Thank you, Mr. Sandinato.
Thank you, Commissioner.
Sir.
Thank you, Commissioner Caston. Commissioners, any other questions?
Chair Belzer.
Commissioner Jay Williams.
Thank you, ma'am. Good afternoon, gentlemen. Thank you for joining us today.
Yes, sir.
I have just a few high-level general questions that both of you can answer if you're able to answer the questions. When it relates to Act 62 matters, would you agree that even if a matter we take up here is under a different docket, say NEM, net energy metering, avoided costs, CPRE programs, would you agree or disagree that even though those matters may come up in different dockets, those concepts, those decisions work together?
Commissioner, I would say yes, absolutely. Everything is intertwined, whether we're looking at a CPRE docket or an avoided cost docket, a field docket, a power plant or transmission line siting docket. These things are all intertwined. We are here today specifically for Siting Act for these two facilities. Our review has focused on them, and it's a matter that we are ready to speak to today, Commissioner, but I will agree with you that yes, all of these things are intertwined.
Mr. Sandinato, did you have any comment on that? Thank you, Mr. Seaman.
No, I would echo and agree with everything.
And so considering that the basis for the need for the two facilities that we're discussing here arose out of the IRP, Santee Cooper's IRP, can you provide any assurance or any opinion regarding how the sufficiency of the IRP considerations, because Santee Cooper's 2020 IRP didn't come before us. So can you provide any assurance or offer any opinion regarding the sufficiency of the decisions they made in that IRP and the level of support used for the decision to issue the RFP and then ultimately enter into a contract with this company, the company here for the two facilities?
Yeah, and it's a difficult question because the 2020 Santee Cooper IRP was before Act 62 or Act 90 brought it before the commission. But Santee Cooper has been able to provide reliable service consistently throughout its history. And the methodology that it used as part of its IRP is consistent with what I've seen in other utilities. And based on Santee Cooper's analysis in its 2020 IRP, it showed that it would be able to provide reliable service through the retirement of the coal plants and also led it to the procurement of this, the solar generation units that we're discussing today.
Thank you, sir. And so I hope you all don't consider the questions coming from my colleagues and some of them coming from me, looking at the doomsday scenario, the worst possible case, as an opinion either way as to whether or not this application should be approved or denied. It's just interesting after spending about 2 years working with Act 62 to see how all these matters are intertwined, as Mr. Seaman Wynn pointed out, and it's very possible to make a decision that can have some pretty significant consequences later on down the road. And I think we're just trying to prevent any decision regret. Is there anything else you think we need to know regarding this application and how it relates to other matters that are before us?
The only other thing I would add is, this is a power purchase agreement that Santee Cooper and Central have entered in, and they will begin to pay for the energy as it's produced on the system, and the applicants have taken the risk to guarantee that it will be invested in and start generating.
Understood, and that's one thing that makes this totally different than the traditional model. There's no risk to Santee Cooper or Santee Cooper's ratepayers for construction, cost overrun, delays. But do you think there's any risk by way of overpayment for the 20-year PPA? Overpayment for the energy, considering whatever their contract price is now, considering energy costs, or not even energy costs, but technology costs may decrease and so forth and so on. Is that a risk worth taking?
I don't know if I could say if it was a risk worth taking. I can say that the modeled price that Santee Cooper looked at is consistent with the price in the PPAs. And if you look at the Enfront Consulting report, it showed overall system savings compared to a base resource case. And so if you're looking at comparing the base case versus integrating solar, the assumptions used did show savings.
I think that's a more than fair statement, but it's also fair to say that no one knows what the future holds, and it's possible over a 20-year period that things could change, the environment could change substantially, and there could be an overpayment. That's not outside of the realm of possibility.
There could, very, very small, but there could.
Right. And so if that happens, no one should be surprised. Right. I mean, let's sort of just put it out there on the table. If that happens, if we approve this application and it's 2022, 2032, a miracle happens, some advanced technology, something, I don't know. I'm praying for something positive as opposed to something negative. And then, the result is 10 more years of paying a price that is now astronomical compared to the current price. That could possibly happen.
I don't know if I would say astronomical compared to what we're seeing with other types of generation, but there could be some overpayment, just like there could be overpayment for a QF that signed an agreement with one of the utilities 3-4 years ago compared to where we are at now.
Right. And it's not that's necessarily a good thing or a bad thing. I think it's sort of a part of the deal. There's no money paid up front. There's no risk to the utility or the ratepayer for construction costs, delays, whatever goes into constructing and maintaining this site. But there could be a risk to overpayment down the road. That's fair, right?
Yes.
Okay.
I would agree with that, Commissioner. And just to add a little more to that, it's important to keep in mind that one of the definitions of prudency is making the best decision that you can with the information that you have at a particular moment in time. Best information that ORS has reviewed, as this case, or as part of a PPA or what have you, as Mr. Sandonato has said, is stated that at this time the prices are in line with what we have seen for other PPAs and such. What that could mean 15 or 20 years down the line, of course, is something that the Commission has to take in consideration. But the information that we have at this time shows that the prices are reasonable. I should also say that I have overstepped a little bit, and that really was not part of the review in this case, that we did look at this docket and the application in context with the Siting Act.
Understood. Thank you for indulging me, gentlemen. No further questions, Madam Chair.
Thank you, Commissioner. Commissioner Caston.
Generated another thought or question, I'm sorry. I think it was, I can't remember who it was, actually. I pointed out, or had Mr. Eccles pointed out that their PPA or contract is simply to install and operate solar array, not guarantee standby generation. And makes sense. I understand that. What are they going to have a gazillion diesel generators out there? Kind of defeat the purpose. But that said, do you know if there's anything in the PPA that what does happen? Like if you do have that catastrophic event, or like, hey, they can't produce power, something really bad's happened. Is there anything in the PPA, or how is that covered, or do you even know?
I'd like to venture into how that would be covered by the system, which Santee Cooper is a winter peaking system, and to meet its winter peak, it has firm generation capabilities that are without this solar generation included. So if the solar's not generating, they won't be purchasing the energy, but they'll still have the ability to meet the system needs based on the current existing generation mix.
Look, I was just curious, and I'm probably getting way out of the area I should get in, but I was just thinking, I wonder if there were any liquidated damages, or doesn't matter. You guys, you probably did. You guys review the PPA? Were y'all given the opportunity to do that, or is that?
Yes, we did. We did review the PPAs, and they were consistent with others that we've seen filed with this commission.
All right, I'll have to think about that more, but I appreciate it. Thank you very much.
Commissioners, any further questions? Commissioners? Hearing none. Mr. Mustin, any redirect?
Madam Chair, just a few brief questions, if you don't mind.
Please proceed.
Mr. Santinato, I believe most of these questions were directed to you, but Mr. Seaman Wynn, obviously feel free to jump on in if you feel like you can add to this discussion. But there were some questions about the reliability of adding these facilities, and I just want to be clear, by adding these facilities, will that directly allow Santee Cooper to retire its coal facilities?
No, it will not.
Okay. So how will these facilities play in the context of whether or not coal facilities could be required, if at all?
These will be an added energy mix to the resource, but when they retire the firm capacity from the coal units, something firm would need to replace those so that they can ensure winter reliability.
Okay, and you certainly can't speak for Santee Cooper, can you?
No, I cannot.
Okay, but generally speaking, when a utility would come in and look at retiring a unit, what are some of the things that they would look at in whether or not they can retire that unit? For instance, would they look at how it would impact the reserve margin?
Yes, they would.
Okay, and would they have to look at how much other generation, their generation mix, those types of things?
Yes, they'd have to look at that, and at the same time, they'd also need to compare what other technologies are available as a replacement for it. And in Santee Cooper's preferred plan, that includes the additional solar that we're discussing. They also have an additional combined cycle coming online.
Okay. And so those types of issues, what kind of proceeding are those generally considered in the context of?
An integrated resource plan proceeding.
Okay. And do you know when Santee Cooper's, it'll be the first IRP proceeding before the commission, I believe. Do you know when that will be coming before the commission?
It'll be in 2023. There are a lot of dates in my head. I believe it's May 15th.
But next year?
But next year,
okay.
Yes.
All right. Thank you, Madam Chair.
Thank you, Mr. Mustin. Mr. Adams, any limited recross?
Sorry, I should look over at you. No, ma'am. Chair Belser.
Commissioners, any limited questions? Mr. Seaman Wynn, Mr. Santinato, thank you for your testimonies today. You may stand down.
Thank you.
And Madam Chair, nothing further from ORS.
Thank you, Mr. Mustin. Mr. Adams, we'll come back to you. You wanted to mention your motion, and you wanted about 90 seconds for closing. Is that correct?
Yes, ma'am.
Okay, please go ahead.
Yes, ma'am. And as to the closing, the applicants have proven their case. I mean, the 5 criteria that are laid out in 160, we've effectively satisfied those criteria. There is public convenience, necessity, and need for the 2 projects.
Mr. Adams, I need you to speak up just a little bit, please.
Yes, ma'am. Yes, ma'am. I think we have satisfied the 5 criteria under the statutory provision at 160. There is public convenience, need, and necessity. We've established that's criteria 1. Criteria 2 is the 2 facilities will serve the interest of system economy and reliability. We've satisfied that. Number three, the two facilities compare favorably to the other generation options in terms of cost and reliability. Number four, the impact of the two facilities on the environment is justified. And number five, there is a reasonable assurance that the two facilities will conform to applicable state and local laws. So we are comfortable that we've made our case. And it's just as a one added final thought, the quick start provision that we've asked for permission under, we would like to renew the motion for that. And we would like to have the ability to get started on the initial construction prior to the formal order being issued here. You know, we've got to deliver the power by May of 2024. We need to start construction in 2022 in order to meet that timeline. And I'm happy to answer any questions about that quick start, Chair Belser.
Thank you, Mr. Adams. Mr. Mushton, do you have anything to add to this?
Madam Chair, just as I said earlier this morning, as far as the quick start provision goes, I believe the statute is clear that the commission can approve initial clearing, dredging, excavation. I don't believe it goes so far as construction, but I could be mistaken.
I think it does. I was surprised at that too.
Okay, then
And construction listed in there is one of the four things that it basically, I mean, I'll just read it to you. It says clearing, excavation, dredging, and construction. Initial clearing, excavation, dredging, and construction.
I certainly stand corrected on that. I did not mean to intend to be the legislature and change the statute, but but again, the statute is clear that if the commission does approve that the approval of those initial activities do not indicate approval by the commission of the proposed site or facility and is done at the applicant's own risk. So with those caveats, we would not oppose their request.
Thank you, Mr. Mushton.
And we understand the rest there, Chair Belser.
Thank you, Mr. Adams. We will now close this hearing and proposed orders. I believe you gave a date of August 8th on the proposed orders. And
yes,
we will consider your motion and put it on an agenda if we're ready to go with it, Mr. Adams. And with that, if there's nothing further from the parties, this is your last chance. We'll close this hearing and thank you all for your presentations, your excellent representation, and your witnesses' nice and excellent testimonies. We are adjourned.
Thank you.